It is now my pleasure to introduce our next session. I will invite out our guest, including our moderator for this session, Professor Elizabeth Pollman of the University of Pennsylvania, who will be joined by Randall Barron of Robbins Geller, Elena Norman of Young Conaway, and Brad Sorrels of Wilson Sonsini. Thank you.
I think it's the other way around, right?
I thought so too, but I think I'll go.
All right.
All right. Well, thank you so much. We're so glad to be here, and what a great start to the morning. There's been a lot of developments in Delaware case law and interesting cases, and we'll discuss a few. There'll be some connection to the session we just heard, and then there'll be a few additional topics that I think we want to discuss. So we're going to dive right in. So one case that we've had an opinion in this year is the Delaware Court of Chancery opinion in the In re Tesla Motors case that rejected the claims that Elon Musk had breached his fiduciary duties as a director and allegedly controlling shareholder of Tesla in connection with the acquisition of SolarCity. And just to set a little background in case that's not all fresh in your mind, in a 132-page opinion, Vice Chancellor Slights held that even assuming Musk was a controlling shareholder and entire fairness applied to the deal, the acquisition's price and process satisfied that standard, negating any liability for Musk in this Court of Chancery ruling. On process, the court highlighted that the board had conditioned the acquisition on approval by a majority of disinterested stockholders of Tesla, relied on advice of independent financial and legal advisors, required Musk and another board member to recuse themselves from the final decision-making on price and from voting on the deal. The court found that the material aspects of the deal were known to Tesla's stockholders, the market, the board. An independent member of the board had led the due diligence process, and the deal price had been lowered. The court noted some flaws in the process, however, a failure to form a special committee of independent directors, that Musk was, quote, allowed to participate in the deal process to a degree greater than he should have been. And the court noted that if he had, and the board, had adopted more objectively evident procedural protections, they could have shown that they were entitled to a less stringent standard of review and avoided the, quote, unnecessary peril of entire fairness. But ultimately, the court was satisfied that the board wasn't dominated by Musk, and it put special focus on price, saying that was an easier call in the case, that there was a fairness opinion. The court noted its view that SolarCity was solvent and never close to bankruptcy. Evidence at trial suggested the market was sufficiently informed, and the deal price was actually lower than SolarCity's unaffected stock price. There was also approval by a majority of the shares voted by the disinterested shareholders. So that's a big case, and I thought we would start by getting just reactions to the Court of Chancery opinion. What do you think are the key takeaways from the practitioner point of view? And I'll start with you, Randy.
Right. Well, look, I think that, the disclosure is important. I was lead counsel on the plaintiff side, so I lost. So, my views are probably obvious. But I do want to sort of bring it back from just a practitioner standpoint, with the reality, like, we settled that case with the directors for $60 million before trial. So I didn't lose any money on the case, right? Shareholders got money. The problem I have with the opinion is really this effort that the court went through to undercut what has been a delicate balance in the development of Delaware law for some 50 years, right? And that is because, and as Vice Chancellor Glasscock was speaking, which is the idea of entire fairness is indeed a tax. You have to understand in a certain situation you are going to be taxed. You have this heavy, heavy burden. And, I'm not using the words. That is the words from the Delaware Supreme Court. Weinberger said it is the highest burden. You have to prove this unitary fair price, fair process analysis. And it makes sense, because it wasn't until, I think, the 70s that you could even do a short form merger, right? There has always been this view in corporate law that conflicted party transactions, self-dealing transactions are, they may be value enhancing, but if you're going to do them, you're going to actually have to go through a very rigorous process in order to get that done, to replicate an arm's length transaction. And so the problem that I have with the opinion is that the court, through all of Weinberger and his progeny, which for us Delaware law geeks, which I hope not all of you are, but, Weinberger is this sort of seminal case in which, we all look back to figure out what that law was. And Weinberger makes it really clear that the burden is heavy and that you have the burden of showing fair process with specific details, right? Whether you instigated, whether you made it progress, whether you were involved, whether you provided full information. And it has details as to fair price, right? As to there having to be an analysis that is an acceptable analysis through acceptable methodologies, all of which means that you have to have this unitary analysis. And the court threw all of that out, right? The court went down this fair price analysis. Well, first off, the court just assumed that entire fairness applies, right? He didn't go through the analysis there.
Isn't that good for you?
Yeah,
I mean, it is what it is, right? We had multiple ways to establish this. He was a conflicted party on both sides. He was actively involved. He didn't provide timely information to the board. He controlled the process. He controlled the financial advisors. So I think I don't think it's good or bad. I just think that we have a process in Delaware, right? That we as practitioners, are putting on our cases, and the judges in the courts and the appellate courts, want to go through this structure. And so I think he should have done that. But beyond that start, where the problem is that the court goes through the fair process analysis, fundamentally finding details that are evident of an unfair process, and never actually comes to the determination on process at all, and then just skips to fair price, and ultimately doesn't rely on any viable valuation methodology. So overall, he just sort of throws out and says, well, I think it was fair enough. And I think that is highly problematic for Delaware law. Like, the idea is that, if you compare it to something like BCG, which again, as a plaintiff's lawyer, I'm sad for plaintiffs having lost an entire fairness case. But, the court in BCG went through a rigorous analysis. She made the determination it's a controlling shareholder, wasn't an issue. The vice chancellor then went through all of the aspects of what would be a fair process and why it was, and made that determination based on factual findings, then made a determination on fair price. And again, I think that's what Delaware has spent a lot of years building this structure to do it. And I think all of that got thrown out.
More views on the Court of Chancery
You told me not to hold back.
Yeah.
Surprisingly,
right?
surprisingly, Elaine and I are going to disagree with a fair bit of that.
What were your thoughts on the Court of Chancery opinion?
So I guess I'll go first. So there's a lot to react to there. On the point about, and I think you said heavy burden deal tax. The tax was we had a trial. And, the standard of review.
That's not what the law says.
No.
The law doesn't say that.
The standard of review and the potential that it was subject to entire fairness is the entire reason that the case was not dismissed at a motion to dismiss stage, and it's why you had to go through the entire discovery process and had a trial. I mean, this is not like secret defense strategy. Trials are unfortunate. We try to avoid trials for a reason, because they're inherently risky.
Right, you make a choice, right? Do you want to do the MFW process or not? And if you don't, you go through the process, and it's a period of years and a lot of discovery, and it's very expensive. And I think the Vice Chancellor recognized that in his opinion.
Yeah, I mean, but fundamentally, so you go through the discovery process and you get to trial, and when you get there, the standard is a preponderance, right? It's 50% plus one. Now, one side or the other carries a burden, but there isn't some heavy lift from a quantum of evidence that defendants, when they carry the burden, that they have to carry.
What is your authority for that? right? My authority is Weinberg that says it is a heavy burden to prove, not to plead. It isn't just a pleading burden. Weinberg, no other case says, oh, we do entire fairness for motions to dismiss, maybe at summary judgment, but at entire fairness, it is just whether or not whoever has the burden, assuming it's not shifted, shows, yeah, it's more likely than not. Where's your authority for that?
Well, it's civil procedure, right? I mean, the standard of evidence, it's a preponderance standard, right? So, whoever carries the burden has to show it more likely than not that the elements of the claim are satisfied, or in the instance of a defendant, that the elements of the claims have not been satisfied. And so fundamentally, the defendants had to prove more likely than not that the price was fair and the process was fair under the unitary standard. But it's not like, so for example, in Delaware, we are a contractarian state. And so we have a higher quantum of proof for proving reformation. It's the clear and convincing evidence standard. In the criminal context, you'll hear beyond a reasonable doubt. It is a higher quantum of evidence that one must show at trial in order to carry the day. In a fiduciary duty suit, it's just the preponderance of the evidence. And if the defendants carry the burden, they have to show more likely than not that the price was fair. And I think when you talk about the elements and the factual determinations that the court made with respect to process, you're also ignoring the positive factual conclusions that he reached. He identified a number of strengths related to the process.
Yeah. So let me push back on the concept of preponderance, because I agree that's the standard. But that is the standard for a determination of facts, right? So if the court has to decide what happened, right? That is what a court does. So in order to decide what happened, right, was there a meeting in which, Elon Musk, in this case, called the bankers and said, you have to come to my meeting, and based on that meeting, did the bankers in fact make a determination to go and push to the Fairness Committee, right? He made that factual finding. Yes, that's a preponderance. That's not the same as making a determination that it is fair. That is a conclusion. And to reach that conclusion, the courts can hold the defendant to the burden of a strong burden. It doesn't just have to be more likely fair than not fair. It has to be entirely fair. That's what Weinberger says. And so, yes, civil procedure, but we have 50 years. 1983 is when Weinberger came out, and there hasn't been a case that says, hey, we are going to lower that standard, those phrases of it being, an honor standard, once we get to trial, because the standard is civil procedure. There's just no authority for that.
Let me ask for Elena's view on this. Do you think, in reacting to the opinion, do you think it was lowering what you expected as an application of entire fairness?
No, I actually don't think it was. I not surprisingly agree with Brad on the standard, but I also think I think the opinion reads very consistent with Delaware law, and in particular. I think about when I read opinions on independence and the courts look at a multiplicity of factors and how you don't just look at one factor in isolation, but you look at everything together. The way I read this opinion is very consistent with that. When the court talks about fair process, for example, he weighs the good and the bad, and he sort of weighs it. And I guess this dovetails with the debate we're just having. Is he required to say that the defendants must show beyond something akin to beyond a reasonable doubt, I guess is what Randy's saying.
No, it's not. I am absolutely not. I am saying that as a preponderance of whether a fact is true or not. Sure. Did this happen? Did that not happen? But ultimately, those facts are what you accept, and indeed the appeal does accept those findings of fact. The question is how you apply those facts to the law. And that is where Delaware law has been undermined, in my view.
I don't think he says the factors are only slightly favoring a fair process, therefore I'm going to find it's a fair process. I mean, he doesn't exactly come out and address that squarely, but I think if you read the opinion, it's clear that he thinks the fairness factors really did dominate the unfairness, in particular the fact that Robin Denholm was independent and took charge of negotiating the transaction. I think he finds that really weighed in favor of the fairness. Similarly, with fair price, he weighs lots of different things. It isn't like he just focuses on the comparison of the market prices, but he also looks at the contemporaneous DCF, he looks at synergies, he looks at cash flows. So again, he's looking at multiple factors and looking at how they come together. And I think he finds that the weight is both on the process being fair and the price being fair.
But I
So
think
let
you
me-
right.
oh,
Oh, sorry. I was
go
to say, but I think you. Sorry, Elizabeth. I think you rightly pointed out that at the end of the day, the fair price element does predominate. And there's plenty of case law that speaks to that. And he had a wealth of factual determinations that buttress his conclusion that fundamentally this was a fair deal. And I think you also have to step back and look at the context. This was a case brought by buy-side stockholders looking at whether the price for a bundle of assets was fair. And so he brought in things like the synergies. He talked a lot about the strategic rationale, which was a lot of what the defendants were presenting in their case in chief was the strategic rationale underlying purchasing these solar assets to support what Tesla was trying to do in creating a broader energy company. And so he based his, and I know we'll sort of speak to in a moment, the criticism of, what did he really rely on when it came to market evidence with respect to the fair price. It was all on the groundwork of, here's the facts that support why Tesla was doing this and why purchasing these assets at the price that they did purchase them was a good deal.
So the case is pending on appeal before the Delaware Supreme Court at this time.
Yes.
So what, in your view, and I'll ask all of you, maybe starting with Elena on this one, what do you think is going to be the key focus of the Delaware Supreme Court?
Yeah, I do think this question of, as Vice Chancellor Glasscock said, the unitary analysis and what does that mean and what's the relationship of fair price and fair process. And I think what Vice Chancellor Seitz did is he sort of said, if the process had been more fair, then maybe he would have required a different price. He really looks at the way those two interlink. But I do think there's room for the Supreme Court to give some more guidance on exactly what is the relationship between the elements. Can fair price overcome a terrible process? That's not exactly the facts here, but I do think, so that's one thing. I also think the question of market evidence and what's we heard Randy a couple of minutes ago when he was talked about what are, it wasn't legitimate, but what are accepted valuation methodologies.
It wasn't illegitimate?
No, that wasn't the word you used. No, when you said accepted valuation
Accepted
methodology.
valuation methodology.
But I think there's going to be an analysis of what was the court's fair price analysis proper, and I think here we see, there's an amicus that was put in by some law professors about the market evidence point, and I think that might be a focus of the court as well.
Yeah, that's where I was going to go is the amici, and just for those who haven't seen it, they essentially argue that the court, and again, I think this is a mischaracterization of the opinion, but that the court relied on stock price as sort of the sole basis for the fair value conclusion. Sorry, excuse me here.
There's an amicus brief signed by a number of corporate law professors.
But and look, I think that could be a fair criticism in an appraisal case. I think an appraisal case is different. In appraisal, both parties carry the burden to prove whatever they articulate as the fair value, and the court, by statute, actually has an obligation to determine what the fair value is, to come up with a dollar value. And I think in that context, it might be a fair criticism to say you have to use whatever the current best practices from a corporate finance perspective. But I think when you're looking at a fiduciary duty case, where fundamentally the judge's only job, is to just weigh the evidence presented by both sides and determine, basically call the balls and strikes, who proved their case more than the other party. In that instance, I think the court is rightly able to rely on whatever is presented to it as the basis for its opinion.
Is it really who proved the case more than the other party? Going back to our earlier discussion.
The burden is, 51% to show up preponderance.
So
and so, again, accepting the burden of proof.
Do you want to weigh in or no?
Sure.
On what you think will be the key focus of the...
Yeah. No, it's briefed. I'm pretty sure what the key focus is. Look, I think there are two aspects of it. I mean, first and foremost is this sort of fear of, drifting away from, again, the concept of what we are trying to achieve, right? We are trying to achieve that, yes, value maximizing transactions, if they're conflicted, can go forward, but that they are going forward under a regime that is saying you have to protect them, and you have to protect that being conflict-free. And the idea that you can say, well, it was fair enough. So as Brad was saying, oh, there were findings that, things were okay, or, Ms. Denholm was there. But Ms. Denholm wasn't appointed as an independent director. There was no SLC. There was no authority. She wasn't at meeting. All of these, she wasn't at any of the meetings that Elon Musk was having with the bankers. She was there for one price negotiation. So again, the protections that Delaware offers are at issue, right? And the idea that, you can just kind of throw fair process out really does undermine it. When Vice Chancellor Glasscock was up here speaking, he says, look, the idea is that a fair process will help you get to a fair price. It doesn't go the other way around because, then, what we don't know, right? The idea of a fair process, and, those of us who, looked at sort of old economics, is fair market value, fair price is willing seller, willing buyer, without any compunctions one side or the other, right? So a full bidding process, right? If you actually have that replicated one way or the other, arm's length, then that is your best value, right? And everything else we're doing through valuation methodologies are trying to replicate that, trying to get to that. So what was the problem in SolarCity, and I'm sorry I'm speaking so long, I guess I spent some time on this case. But the problem was that you can't go to trial with your own expert and not rely on it, right? So this is fundamentally, they did not rely on what Professor Fischel did. They didn't rely on Fischel's valuation methodology, and ultimately the court didn't either, and you, even out of your own mouth, the court did rely on the fact that the price 5 months earlier was higher than the deal price was eventually, even though there were headwinds and other problems and a deteriorating business model. Wait, let me finish and then there was a fairness opinion that was, again, infected, using the chancellor's words, infected by Elon Musk. And what the court and their own expert, they did a DCF, which their own expert said, I would modify to be below the deal price. And they didn't rely on that. So again, it's problematic if your burden is entire fairness and you are not relying on your own experts to get there.
Do you think
Okay,
the process
hang on one
has
second,
to? Oh, sorry.
Elaine. I think we've gone deep on entire fairness, and now it's on everybody's radar to watch this case. And you
We're
can
actually just
see
gonna argue
there's a range
backstage,
of perspectives. This is a practitioner's guide to Delaware. There's a range of perspectives as far as Delaware practitioners. But another implication of the case, potentially, that was noted in this amicus brief that we've just discussed, was that maybe there would be some implications for the incentives to use the MFW framework. But I want to move us along to MFW case law more generally, because this past summer in a case involving the trade desk, VC Fioravanti issued a decision that applied MFW to grant a motion to dismiss in a novel context, which was a challenge to a shareholder-approved charter amendment extending the sunset of a company's dual-class structure. And Brad, I know you've worked on this case, and I want to hear your thoughts, if you would share them, of whether that case has any lessons for practitioners on either what independence-related factors for special committee members may be found to be like MFW compliant if we're in a world in which we're looking at MFW, or the level of disclosure aspects of something like this, when you've got a controlling shareholder with a dual class structure, that was clear in that case.
Yeah, and I think I'd actually step back and just say in general, I think the case and the match case was mentioned earlier, another decision recently by Vice Chancellor Zern, I think do reflect sort of a solicitude for transactional parties when they intentionally structure a transaction to comply with MFW and they subject it to the conditions ab initio, they structure the vote in the right way, they exclude the right parties from the minority for purposes of the majority of the minority vote. And if you recall, we used to actually litigate over ab initio, like that. In the early stages of MFW, it was always sort of, was this structured properly? And I think now you're seeing transactional planners, being very intentional in structuring a transaction so they get the benefit of MFW, so they can avoid a trial, and they can walk into court fundamentally and hand the judge a piece of paper, a brief, and say this case should be dismissed. And so I think there's a little bit in the more recent cases a solicitude for when you've taken those steps and you've done everything you're supposed to do that we as a court are directing transactional planners to do, that it's not going to be upset by sort of throwing a bunch of disclosures at the wall and hoping that one sticks. And I think the trade desk case was a good example of that, where the plaintiffs came in, they couldn't challenge any of the elements of MFW other than the fact that the vote was fully informed, and then they had a sort of a minor challenge to the independence of the committee. And on the disclosures, I think the sort of headline disclosure was this concept that the controller's motivations were not adequately disclosed. The controller's desire to have this charter amendment that would extend his or her control was not adequately disclosed. And I think the court rightly said, well, no, that's obvious on the face of the proxy. The controller is proposing this because the controller wants to maintain control. And so there it was an allegation that the controller wanted to continue to sell shares, and the court rightly said, look, some additional minutia around the controller's motivations wouldn't alter the total mix, and therefore was not a basis to upset, 18 months later, what the transactional planners had done in choosing to go with the MFW standard. And then the other piece of it was the controlled mindset, which I won't repeat because I think it was covered pretty well earlier.
Yeah.
But
any other quick lightning round on observations of the MFW trend line and whether we're seeing, some have called it maybe MFW creep. Like this case is an interesting case in that MFW framework was used for something in a novel context. So are we seeing other instances of that?
okay.
Well, I was just going to say, there's at least one case pending. A complaint's been filed, and I don't think an answer or a motion to dismiss has been filed, but it gets to this ab initio point because a transaction was structured fully in compliance with MFW, but then the plaintiffs are saying there was actually a series of transactions, and you should look at all the transactions as linked. Therefore, the conditions weren't applied ab initio. So I think we're going to see some interesting litigation on that question as well.
Look, I think that MFW was actually a very well-crafted extension of thoughts that have been going on in Delaware for a long time. And the fact that it is extended beyond just your merger, I don't think really surprises because, again, as the discussion was, before the balance is always between some economically rational plan and to insulate against conflicts of interest, right? And MFW is the way to do it. And what I fear is that both on the plaintiff side and on the defense the defense side, which is that plaintiffs are going to try to undermine that, right? Which I think has real value, right? By making ridiculous arguments.
So
right?
maybe we shouldn't call it MFW creep, but extension or a more positive.
Yeah, I think it is actually a reasonable extension, but the downside of it is that I think it is part of the regime to say, we want it, right? We really would like the opportunity in almost any circumstance to have an arm's length transaction and an independent shareholder body make that decision, right? And so any time in a conflicted party transaction that you don't have it, I think it is more than you just don't get to the business judgment rule, but it's more that you are showing a process in and of itself that is flawed. If you don't want to take it to your shareholders, for example, to have them confirm it when you have a methodology for doing it, or you do not want to put together an independent committee, and you cause problems. And I want to add one other thing that sort of came up when Brad was speaking earlier, which is talking about the tax being trial, if I can. Just because, there's an article written by Meredith Kotler after BCG in which she noted that, these opinions, both SolarCity and BCG, are in fact undermining the very regime of MFW. And because controllers are saying, why not? Why not take that risk? Because it's not their money, right? It's not their money that's being paid in order to go to trial. Yes, and they're going to sit for a deposition and maybe go to trial. But again, it's not their money that they're wasting to go to trial. And they now get to do what controllers like to do, which is control. Like, if I can make sure the transaction I want is happening without that tax, then they're more likely. And this was indeed what Meredith Kotler was saying. Some lawyers are actually advising their clients. So it's creeping the other way as well.
But the price still has to be fair for them to win in that scenario. So in that sense,
but if all you need is stock price, then it's, if all you need is stock price, then it's fair, right?
But again, I think you're not accounting for the risk, and you're also not accounting for the time and energy spent in discovery, which is becoming more and more invasive. And so distilling it down to just defense costs, it's not my dollars, it's D&O dollars, I think misses that. The reality is, and I think most triers of fact would say this, if you try a case twice, you may not come to the same place. Trials are ultimately performative, right? Witnesses have good and bad days. Expert testimony can be viewed as more or less credible depending on how it comes in. And so there is inherent risk in taking a case to trial. Now, you managed to find the one fiduciary who said, bring it on, and I applaud you for that. But most fiduciaries, I think, would routinely agree that trial is not the objective, that there's a way to structure this transaction to have process elements such that I can avoid 2 years of litigation or trial. I'm going to do it.
And there's risk in whether or not the price is going to be found to be fair.
Yeah. Okay, so again, we have a range of opinions and another trend to watch. Let's shift gears to yet another development that we've seen, this one in the statute, 102B7, and officer liability. So since its adoption in 1986, DGCL 102B7 had authorized the corporation's certificate of incorporation to have an exculpation clause that limits or eliminates the personal liability of directors for monetary damages, breach of the duty of care, right? But now it's changed to allow for something more, which perhaps is in response to a trend line that we've also seen of a number of cases with fiduciary duty claims against officers and cases like Morrison versus Berry, et cetera. So recently, DGCL 102B7 was amended to authorize exculpation of certain officers for personal monetary damages from a breach of fiduciary duty in certain actions, direct claims brought by shareholders, including class actions. So this is a pretty significant development, and I'm curious to know, from a practitioner standpoint, what do you think the statute is doing as a practical matter, and what sorts of questions are you hearing from clients, and are you seeing this, corporations getting amended? So what's the buzz in the practitioner world on the 102B7 change? Brad? We'll go this way.
Yeah, I'll go first. So I think you sort of noted the one very important caveat or practical limitation is it does not cover derivative claims.
Yep.
And really what it gets at are I'll call it the Morrison v. Berry claim, right? The direct claim against an officer related to disclosures. Really think about just M&A claims. Claims that arise from M&A cases are typically direct claims. Those are the ones that it's really intended to get at. And I think as a practical matter, it helps bring down D&O costs. I think what we're hearing from sort of clients right now is really sort of trying to understand that distinction, what's covered, what's not covered. I think there's also a focus on, how is ISS and Glass Lewis, the large institutional holders, how are they going to view this? I think we're sort of in an off cycle, right? I think we'll see more proposals in the spring during the typical proxy cycle. I think currently ISS and Glass Lewis have come out in favor, for the most part. I think they were in favor of Fox's proposal. I think the perception among practitioners is that it probably gets viewed similarly to the forum selection provisions from several years ago, something that is helpful to bring down D&O costs. It's consistent with Delaware law. It's not inconsistent with stockholders' interests. And so I think we're generally going to see some receptivity from the advisory services and the institutional holders. So I think you're going to see more companies adopt them. But those are sort of the things that we're talking through currently with clients.
Yeah, I don't have anything to add to that.
Do you think, I'll ask Randy a slightly different question.
Because I have no idea what the clients are
Do
doing.
you think this would likely change strategies on litigation or the cases that we'll be seeing?
No.
Yeah.
I don't think so. I think that there is a theoretical problem, but not a practical one, right? So plaintiffs aren't bringing claims generally for duty of care. They're bringing claims for duty of loyalty. Morrison v. Berry is a really good example. The core of that case was the founder's self-dealing and the founder putting that company in play, et cetera. So again, and it has, and even in the cases in which courts upheld, for the most part, because they're mine, but the cases in which the court upheld duty of care claims, those were ancillary claims. I mean, those were pled, but there was a duty of loyalty claim there. And, ultimately the standard for a duty of care claim was gross negligence, where the standard for bad faith is going to be, conscious disregard. It's a continuum of conduct. So again, I don't think in the long run it's going to have that much of an effect. I think the problem more theoretically is within the corporation, and which is why I'm curious to see how ISS and some of the other proxy services actually look at this, because what you've done is disincentivized officers from seeking board approval of conduct, right? Because now if it's just a duty of care to go and bring this up and getting the board supervision, then they are not at risk. So you have the opportunity for more rogue behavior. And I didn't just make up this idea. So when 102B7 itself was being discussed, there was a discussion about whether or not there should be officers along with directors at 102B7 in the conference. And one of the arguments against doing so was that you were going to disincentivize, and now we're talking about really highly paid individuals, right? The officers are being paid hundreds of millions of dollars, and you're disincentivizing them to get that board supervision. And I think that's problematic.
And I think that's what underlies the decision to carve out derivative claims from the statute, because you put yourself in the shoes of directors. You want officers to come to you, and when you're talking about a claim that ultimately results in harm to the corporation, there may be instances where holding officers to the duty of care is necessary.
Okay, I truly mean a lightning round because time is dwindling. But we heard from the previous panel about Caremark, and I just wanted to give an opportunity in case there were any reactions that you wanted to make observations or about other cases to watch or recent cases to note.
All right.
Elena?
Yeah, I think one interesting context in which there was a reference to Caremark was it was the ODP, I think Goldstein case, where Vice Chancellor Laster actually held that it was a case that involved exceeding limits of a compensation plan to pay a director more than the plan would allow. And stockholders sent a demand to the corporation, and the corporation the directors didn't fix the...
That's very lightning.
You should talk.
Fair.
Didn't fix the grant, and Vice Chancellor Laster actually found that on a motion to dismiss that it was a kind of a Caremark situation where the directors were on notice of a potential violation based on the letter from the stockholders, and it gave rise to a quasi-Caremark claim. So I thought that was interesting.
It is, and there's still so much more on Caremark to watch, I think that shows, and thank you so much for raising that. So thank you all.
I want to do my lightning round, which was death is mission critical. We accept
that truly
that.
is a lightning round.
We
yes.
can accept that death is mission. If you're worried about mission critical, if someone can die, it's probably mission critical.
And I will.
Well,
I
not
will-
necessarily in the Hamrock case.
Okay, well, to be continued over coffee. We thank you all so much.
Thank you.